Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Peter Sachs. To my right, your left is Justice Suk-Young Shin. To my left, your right is Justice Rachel Hershfang. Will be your panel for all 5 cases this morning. One of our 6 came off the list. If you've been to the Appeals Court before, you know that we've read your briefs, we've looked at the record, we're familiar with the factual background. We encourage you to get right to the heart of your arguments, and because 15 minutes goes quickly. The yellow light will come on when you have 90 seconds left, and the red light means your time is up. So with that, I will call the first case, number 24P270, Commonwealth versus WINAM. Let me know if I mispronounced that, please.
I believe that's accurate, Your Honor. Good morning. May it please the Court, Edward Crane on behalf of Jeremy WINAM. The question here is whether the police had reasonable suspicion that the defendant was engaged in criminal activity at the time that he was stopped. They did not. To establish reasonable suspicion, the police needed evidence that the defendant lacked a license to carry. The Commonwealth argues that 3 factors support the conclusion that the defendant was unlicensed. Number 1, the defendant's evasiveness. Number 2, the defendant's holding of his side. And number 3, the defendant's denial that he was in possession of a firearm. With respect to evasiveness, this is irrelevant to the reasonable suspicion analysis because it was observed after the defendant was already stopped. The testimony on this point is absolutely clear. The officer testified that the defendant was evasive. He just wanted to get going after he was stopped for the second time. Furthermore, there were no specifics whatsoever about how the defendant was evasive, and thus, even if this could be considered in the reasonable suspicion analysis, it would be minimally probative of the defendant's lack of licensure. With respect to the defendant's holding of his side, this is irrelevant, again, for the same reason. The police did not observe this until after the defendant was stopped for the second time. Again, the testimony on this point is clear. The officer testified that he observed the defendant holding his side after he was stopped for the second time. Finally, with respect to the defendant's denial that he possessed a firearm, this is irrelevant to the reasonable suspicion analysis because under the Commonwealth's logic, reasonable suspicion that someone possesses a firearm, followed by the person's denial that they possess a firearm, equates to now not just reasonable suspicion that they possess a firearm, but also reasonable suspicion that they don't have a license for the firearm. There's no case law that supports that proposition, and I think it's illogical to follow that premise.
Well, if the officer himself from behind saw the defendant take a gun out of his pants and then put the gun back in, and then he walks right up to the defendant 10 seconds later and says, "Hey, do you have a gun?" And the defendant says no. Would the defendant's denial of something the officer knows to be true create reasonable suspicion that there's something unlawful about the defendant having that gun?
Yes, that's a different scenario. If the officer is sure or can confirm that this is an inaccurate statement, then certainly the denial in that situation would be indicative of consciousness of guilt and thus support the idea that the defendant would not have a license.
So then does it all come down to whether the description was sufficient to justify the same inference where the officer didn't see it directly but had a report of, man with a camouflage top and a fresh haircut?
Yes, I think in some respects it does come down to that analysis, and I would say that the description here is enough to at best, it's reasonable suspicion that the defendant was in possession of a firearm, but it's not to the extent that Your Honor displays in that hypothetical, the observation that clearly this defendant has a firearm. Now I approach them, ask them if they have a firearm, they say no, then that's obviously a different scenario because it's clearly a lie. And the Commonwealth characterizes it as a lie in their brief, but I don't think that can be established here because again it's reasonable suspicion that this person has a firearm, but does that I guess the idea that the police could have reasonable suspicion that someone possesses a firearm, then approach that person, ask them if they have a firearm, and they say no, and now they not only have reasonable suspicion that they possess a firearm, but also reasonable suspicion that they lack a license. I can't follow that.
Is there actually testimony that the officer asked him whether he had a firearm? Because when I read the testimony, it seems like the conversation was, we got a report of someone brandishing a firearm, and the defendant says, wasn't me. To me, asking, are you the person who was seen brandishing a firearm is a different question than, do you have a firearm? So is there any testimony that he even asked him whether he had a firearm?
That's a great point, and I wish I had seen that myself, Your Honor. But I think you're right. That is the testimony. That it's a little.
You're not aware of any testimony. It's not a long transcript, but I didn't see anywhere in the testimony where he said, I asked him, do you have a firearm?
It's not that direct a statement. It's, I believe his answer. There's one answer that is the entirety of the first conversation, and it's essentially, I asked him, like you said, if that I was investigating someone who had brandished a firearm, and if I had asked him if he had seen anyone or if he was someone who had done that, and he said no. So I believe that is the extent of the testimony.
Yeah.
Any further questions? Seeing none,
Thank you, Your Honor.
thank you for your argument. We'll hear from the Commonwealth. Good morning.
Good morning, and may it please the Court. Brooke Hartley for the Commonwealth. This Court should affirm the defendant's convictions where the defendant's motion to suppress was properly denied. Police had reasonable suspicion that the defendant was carrying an unlicensed firearm based on the defendant matching the description of the 911 caller and his subsequent lying to the police. Now, I would first just like to point out that the defendant is correct. I have a misstatement in my brief where I said that the officer testified that he was evasive before the stop. He said the word evasive, and that came after the stop. However, I would argue that his conduct before the stop, although the officer doesn't use the magic word evasive, is evasive. His lying to the police when the officer asks him if he I was looking right now at the testimony, Justice Shin, to see what the exact language was, and I didn't quite find it, but I do believe that he...
On page 8, I think, is the key.
So on direct, he says that he told the defendant, we're investigating someone who had just, brandished a weapon, asked him if he had seen anyone who could have done that, and he says he denied seeing anyone or being anyone that had done that. And to me, that's not necessarily lying, right? Because if the officer says, I saw someone who brandished a weapon, was that you? I mean, brandish can be interpreted in different ways, right? So
I would agree that the testimony is not clear. There's a lot of the testimony that's elicited is not particularly clear. There's some ambiguity on several points, but I do think he denies having a firearm. It's not exactly clear what the question was, but I think from this testimony we can infer that he said he hadn't seen that person.
He denied seeing anyone or being anyone that had done that.
Yes.
Right?
Yes. And I think that still, again, this is an objective standard. We're not trying to get into the officer's head to determine whether he believed this person was lying, but objectively, when you have an individual who I would argue meets a non-generic description, this is not like the descriptions in Warren and White, or even in the cases my brother cites, Gomes, Alvarado, Sertle, where you just have a defendant's race and a backpack or a gray sweatshirt. You have a camo top, which is a distinguishable article of clothing.
Like a goose down coat?
I think that would be in New England in the winter, a goose down coat is a common article of clothing. I think the language, this isn't in my brief, but in Henley, the court says, Commonwealth v. Henley, it's Judge Cipher's opinion, says the description was not so general that it would include a large number of people in the area where the stop occurred. I think when we look at an individual with a camo top, having a fresh haircut.
I don't want to distract from Justice Shin's question, but I wonder if we need some evidence about whether a camo top is common. Anyway, I didn't mean to distract you from...
Yes, Your Honor. So my answer to your question would be that although the testimony is not perfectly clear, I agree with you. I think there is testimony that he denied seeing that person, and he denied brandishing a firearm. He denied holding a firearm.
Right. So that's not necessarily, again, I don't see how objectively you can say that's lying. So what if the officer testified that he told him someone reported seeing a person waving a gun around, and he said, wasn't me? That wouldn't be lying, right?
Well, also, I think we're getting away from the reasonable suspicion standard here. So whether or not he's lying doesn't necessarily, maybe my use of the word lying is not the most helpful to our argument, because I think, again, the touchstone here is reasonableness. You have a 911 caller, a concerned citizen, calling to say that there's someone with a gun. A police officer doing his duty investigates that, shows up, asks some questions, finds out from the convenience store clerk that there was someone matching that description in the area. He goes outside, he locates this person not far from the food mart. He locates a person matching the camo description, white male wearing a camo top. And I think the reasonableness of this encounter is shown by the officer's actions. So he asks him those questions. We're not entirely clear on exactly what the questions are. And then he sends him on his way. And it's not until...
That's not the stop we're worried
No,
about,
Your Honor.
right? And I think, and one thing that would be helpful to me is just to make sure we're all talking about the same moment in time. So it was clear from the transcript, and I think also from the decision on the motion to suppress, that the stop that's at issue here is the second stop, and that everyone agreed that actually the defendant was seized in a constitutional sense when the three officers converged in their three cruisers with lights on and surrounded him. So at that moment, the officers know there's a guy in a camo top with a fresh haircut who was seen sticking a gun in his waistband, and this person that we're approaching has denied that he was that guy. Is that what we were looking at?
That's right. That's right. Yes. And the Commonwealth's position is that those factors are enough to support reasonable suspicion. Now, there's one additional factor that the testimony is not clear on. My brother says that the testimony is perfectly clear. I think it's anything but clear, and that's him walking away holding his side. The discussion is on page 16 of the transcript, and it initially reads very clearly as if he says, the question was, and while walking away, you didn't see any furtive movements or odd behavior, correct? And the officer responds, he just kept, the only odd behavior I would point out is he kept holding off to his side, which he did explain to me that was from an injury. And then he contradicts himself shortly thereafter. But the motion judge finds that this happened before the stop. And
That's inconsistent with the police report, isn't it?
You know, Your Honor, I'm not sure if it's inconsistent with the police report. I apologize, and I can certainly look at that.
That's my memory, which is also faulty.
I can certainly look at that and submit a 16L.
Whether clear error or not, what does it add when you don't have any testimony from the officer about what conclusion he drew from his observations?
Agreed. This is so, like, if you look at a case like DePisa, the officer testifies that, you know, in my experience, a illegal firearm is often
So someone
handled this way.
who walks strangely, I don't see how that really adds
I
anything.
think it has minimal value, and I think the Commonwealth would still prevail without that, but I do think it colors the analysis. Again, it's a reasonable suspicion. We're not talking about anything more than reasonable suspicion, and I would argue that, again, the officer was acting in a reasonable manner, which is shown by, as I was beginning to say, how he allows the defendant to walk away, goes back, receives another detail from the officer who is now, another officer who is now talking to the 911 caller, says, oh, and he had a fresh haircut, and then the inference
What does that mean, a fresh haircut?
Your Honor, I took it to mean it was, he had just had a haircut. I suppose it could also be
How do you know if
slang.
someone just had a haircut if you don't know the person?
I noticed when you just had a haircut.
She knows me.
You know, again, I think it's one detail that the officer believed matched to the description of this person.
I don't really understand what it means unless they're saying a very short cut.
And I would agree with Your Honor that the testimony is limited. This is another point on which we don't have a lot of clarification. But again, I think it's a different description than all of the cases my brother cites, which are Gomes, Alvarado, and Sertle, he revised, and Edwards, but I'll get to that separately.
Can we talk about Edwards? Because
Sure.
you don't address it in your brief, and I think it's pretty hard for you.
So I would argue the opposite. I would argue that Edwards actually supports the Commonwealth's position here. So in Edwards, you do have a tip that's not anonymous. You have an individual calling the police who identifies himself, also knows the defendant. So that's perhaps more than we have here. But really what you have in Edwards is this non-anonymous tip and suspicious behavior. So the suspicious behavior in Edwards is he sees the defendant outside the car holding a gun, goes in the car, drives away, comes back, gets out of the car. Kind of odd. And the reason I would argue that the suspicious behavior...
Well, I mean, hold on a sec, because I think there's more that distinguishes Edwards. So in Edwards, it's 1:30 in the morning, and it's a location, parenthetical, a deserted street in a residential area within a few blocks of which there had been repeated crimes of violence, including gun violence and homicides.
Sure, so it's a high crime area.
As opposed to like the food mart in the middle of the day.
Well, we don't have any testimony about whether or not it's a high crime area. It certainly is in the middle of the day, but we know that the court adds very little value to high crime area. And I would suggest that the behavior, certainly, and Your Honors, certainly this is a close call, but in Edwards, the behavior is not lying to the police and perhaps misleading the police in this case is not a crime. But in Edwards, the getting in and out of the car, driving away, coming back is also certainly not a crime. And I think the difference here and why I would suggest that this case is perhaps a little bit more compelling, although you don't have the middle of the night deserted street factor, is that the denial of being the person when this individual matches what I would argue is a non-generic description is perfectly tied to the crime that they're investigating, which is illegal possession of a firearm. Whereas I'm not sure what getting in and out of your car, leaving and coming back, what crime they would be investigating. That doesn't suggest that it's an illegal firearm. It's just suspicious behavior. So I think the two factors we have here are comparable to Edwards. You have the non-anonymous tip, you have the individual who's actually talking to the police, and you have this suspicious behavior. And I would distinguish this case from the cases my brother cites, which is Gomes, Alvarado, and Sertle. In all of those cases, you have an anonymous 911 call. And the court is very clear that that is a big factor in determining that the motion to suppress should have been allowed. Also, the description in all of those cases is generic. In Gomes, you have a black male wearing a gray sweatshirt, standing out green pants, which it's unclear whether there's actually findings that the individual the police see is wearing green pants, standing outside a green Honda. Alvarado, you have anonymous 911 call, several Hispanic subjects observed inside a car, a blue vehicle. In Sertle, you have 3 black males wearing hooded sweatshirts and backpacks. These are all generic descriptions that are similar to those in Warren and White and what the court has said are common generic descriptions that would, there's plenty of people that would satisfy those descriptions. And there's also little corroboration in those cases. I would argue that here, excuse me, we have much more corroboration. First, because the individual was seen, it's unclear, again, based on the record, how long it took the officer to get to the area, but we do know that he was in that location. He testifies that he was on patrol in Prattville, which is the area of Chelsea where this happened, and that when he received the call, he went to the area. So I think there's a logical assumption to be made that he went immediately, or in close temporal proximity. In terms of physical proximity, we know, although there's some confusion as to the street names, if you look at a map, I'm not sure they're all right in the testimony, but we know that he's in close vicinity to the food mart where he was seen. I would also note that my brother argues that the motion judge's finding that he said, yes, I was just in the food mart and I bought some candy, happened after the stop. So he does testify to that, but the testimony, he says, excuse me if I could find it, I believe he says, yeah, he told the officers the same thing he told me, that he was in the food mart and bought some candy. So if we take that to mean that he also told the officer that before the stop, we also have further corroboration that it was the individual the caller was calling about.
All right, seeing no further questions, thank you both for your arguments.
Thank you, Your Honors.
All right, our next case will be 24P199, Commonwealth versus Liu. Right, second case is off the list, so you're up. No problem, thank you.
I did the same thing.
I should have said at the beginning which case was off the list. I apologize.
Does the clock get changed back to?
I think we can change the clock back to
Thank you.
15 minutes.
Just for you, though, Mr. Sultan.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. Like many sexual assault trials, this one was essentially a credibility contest between the complainant and the defendant who testified at trial. This one was a little different because the defendant filed an alibi notice and presented an alibi defense. And his alibi was that on the morning of July 26, 2017, including 12:40 a.m., when the complainant says he was sexually assaulting her, that the defendant was on a lengthy FaceTime call with his fiancée, Pei Wang, designing their wedding invitations and talking about arrangements for their families to...
So let me cut to the
Yes.
elements of ineffective assistance. So how is it deficient for counsel not to foresee one particular tack that the Commonwealth was going to take on cross-examination?
Why is it not deficient?
No, I'm sorry, why is it deficient? I apologize. I mean, the counsel said at the motion for new trial hearing, we didn't anticipate that.
Right.
Is counsel responsible for anticipating every possible attack that the Commonwealth is going to make on cross-examination?
Well, of course, Your Honor, counsel cannot anticipate everything, but of course, counsel is responsible as part of trial preparation to anticipate, well, what are the weaknesses in my defense, and how am I going to address those weaknesses at trial? That's what trial lawyers do. And in this case, there were two clear weaknesses in the alibi. Weakness number one was that there was no documentation of that FaceTime call. And weakness number two was that there was no explanation of why there was no documentation other than the testimony of the defendant and his fiancée that after he was charged, which was more than 3 months after the alleged assault, that they looked for records and were unable to find them. And it was completely predictable what the Commonwealth did, which was to drill down on those two weaknesses. That alibi was at the crux of the case. If the jury believed or even had a reasonable doubt about whether that FaceTime call had occurred as the defendant and his fiancée testified, he was almost certainly going to be acquitted. But if the jury believed that he and his fiancée were making it up and fabricating it, which is what the Commonwealth contended, then he was almost certainly going to be convicted. So, of course, it was part of the defense counsel's job to say, okay, we're putting in this alibi, we don't have any records, how are we going to explain to the jury, especially in this day and age, when everybody expects that everything in the world is documented,
Well, but
especially
the
things
claim-
that happen online?
The claim, as I understand it, is limited to counsel's failure to consult with an expert. That's the limitation of the
No,
claim,
Your
right?
Honor, the claim is counsel's failure to consult with and present an expert.
But it's focused on the expert, right? So
Totally.
counsel testifies at the hearing that she did her own research and found out that it was Apple's policy not to retain these records for more than 30 days. So why is it deficient, if you've done your research and you know this is the policy, to think, well, there's no point in consulting with an expert because I know there are no records?
Well, because, Your Honor, as I said, there were two weaknesses. Weakness number one was no records, but weakness number two is how do we explain to the jury that there aren't records? And indeed,
So let's say after the cross-examination of the defendant, defense counsel put in the policy in some way or form, Apple's policy, written policy that they don't retain records after 30 days. Would that be effective?
well, that would have been better than nothing. They would have had to authenticate
Right, so
it in
why
some
is
way.
it necessarily deficient not to put on an expert? It seems that really the claim is that defense counsel didn't respond adequately to the cross-examination, but that didn't have to be an expert who came in to rebut that testimony, right?
Well, Your Honor, perhaps you could do it through documents, but frankly, the Apple gobbledygook policy would not be nearly, in my view, as someone who tries cases, would not be nearly as effective as putting someone on the stand, an expert, to explain what FaceTime is, how it works, why there aren't records on Verizon or T-Mobile, while it's only Apple, and that Apple at that time did not retain any records more than 30 days, and therefore, when these folks looked for those records in November of 2017, they would not have been able to find them. As the Commonwealth concedes, that would have corroborated the defendant's testimony that he looked for them and couldn't find them.
I don't think you're right about that, Mr. Sultan, because the hole I see in the effort that you have made in the motion to for the new trial is that those records appear in two different places, and you've addressed only one of them. So you have addressed, and you have claimed that trial counsel was ineffective for not addressing the absence of those records on the Apple server. But the cross-examination of your client and the cross-examination of the proposed expert at the motion for new trial also speak to the fact that those records are available on a device, on an iPhone or a MacBook. Your client was asked about that at trial. Did you look at the device? Did you look at the logs? There are logs there. You didn't delete the logs. No, I didn't delete the logs. There was nothing there. There was no testimony either at trial or in connection with the motion for a new trial that addressed whether those logs would have remained on the phone. In other words, I didn't see anything in the record that implied, and I know as an iPhone user myself, that it is not true that Apple somehow sucks records off of devices after 30 days. The 30-day policy goes to the federal requirement in 18 U.S.C. 2703D that records be retained by the carrier for a certain amount of time. But the updates to what is in Apple's records does not necessarily, or there's no evidence that it would push through to what's available on the device.
As I recall, Your Honor, and I may be wrong, but as I recall, the expert looked on the cloud and was unable to find any such records. And in any event, even if that is a potential other place they could be, it doesn't matter that it's not ironclad. I mean, look at what the prosecutor did on cross. He says, and this is quoted on page 19 of my brief, would you be surprised to know that the FaceTime, long afterwards, FaceTime logs remain far after 30 or 90 days? Would you be surprised to learn that? I mean, that's the kind of cross. There was no good faith basis to ask that question. He spent page after page after page.
Well, I don't think that's true. I mean, good faith basis, what if the prosecutor has an iPhone and he's looked at his own iPhone and it has records going back farther? Isn't that a good faith basis?
No, Your Honor, that's not how we try cases. You have to have evidence in order to ask the defendant on cross-examination a question that has a factual predicate. I have an iPhone too, but I'm not a witness at the trial, and the counsel can't be a witness at the trial. You put on an expert to explain to the jury why this gap exists, why there are no records that are available, because the absence of records and the absence of any explanation other than the defendant's and his fiancee's arguably self-serving testimony that they tried and couldn't find it, it was all that the defense had to support essentially their whole defense. And the Commonwealth, therefore, was able to drill down on cross-examination for page after page after page, lampooning his efforts to look for the records, and then in closing argument, argued that it was a fabrication. Of course, it was incumbent upon the defense to anticipate that totally predictable line of attack and to do something to blunt it, even though, I mean, the motion judge says it would have blunted the attack. The prosecution in its brief says it would have corroborated the defendant's testimony that he couldn't find the records. So I don't think there's any issue. I mean, to me, there's no real, the issue to me in this case is prejudice. The issue really
can we talk about the ineffective assistance standard for prejudice? So this is not failure to present a particular defense. He presented the alibi defense. This is not failure to present evidence that tends to prove the alibi defense. The explanation for why there might not be records doesn't make it more likely than not that the call actually occurred. What this is, as I think you said, is an effort to fill a gap. I would say it's a failure to bolster the defendant's credibility on what's a collateral issue. It's not direct. It's not directly to the truth of the alibi. It's a defense to an attack.
Well, yes,
and my question is, long-winded as it is, can you cite us a case where that sort of gap, failure to present that evidence, is prejudice, is a deprivation of an otherwise available substantial ground of defense, or accomplish something material for the defense?
Well, I don't have a case just like this one, Your Honor. Let me say two things in response. Number one, I mean, the word collateral to me is
Okay.
which is sort of a,
It's a way of dismissing things. Okay.
Right.
So you can take that out of the question.
I mean,
okay. So the question is there a case that says that this sort of evidence that does not directly support the defense, but merely shores up a possible hole in it, failure to present that evidence is prejudice?
Well, Your Honor, I cite in my brief a number of cases that stand real, they're not like this case, but they stand
They all seem more direct to me.
They stand for the proposition if you're going to put on an alibi defense, you have to present it competently and effectively and do whatever you can to bolster it.
Right, but we have to have some, I mean, you can always do more. But those cases involved failure to present evidence that could have directly supported the defense. And maybe direct, indirect is another distinction that may obscure things, but we need some objective way of deciding what prejudice is.
Your Honor, respectfully, I think the standard, I mean, it's not a bright line standard. I mean, it goes back to Satterfield and Safarian, and would better work likely have done something for defense. It's a mushy standard, but to me, you look at the totality. You look at, well, was this a particularly strong case? No, this was not a particularly strong case. The only evidence the Commonwealth had was the testimony of the complainant, the testimony of the first complaint witness the next day, saying that she complained, and in fact, when she complained, she said she wasn't sure, and then the testimony of an officer who talked to her months later. So it's not an overwhelming case. It's not a particularly strong case. It is, as this court has said, and the SJC has said in many cases, sexual assault cases, a credibility contest. So in this kind of a case, the credibility of the defendant is critical, and any evidence which goes directly to his credibility, which this does because of the way the Commonwealth attacked him, both in their cross and in their closing, is important. How important is it? I mean, that's a mushy standard. But the question is might better work have done something for the defense? That's
something
what
material,
Satterfield says
something
50 years ago.
material for the defense,
Yes,
right?
Your Honor, something material. And in this case, where the Commonwealth itself says it would have corroborated his testimony on this point, where the motion judge says it would have blunted this aspect of the cross-examination, I submit in this kind of a case, okay, no videos, no physical evidence, no confession. It's a credibility contest, and particularly in this kind of a case, something like this could have tilted the balance in terms of credibility and changed the outcome of the case.
So
and
the problem really is the cross-examination, right? So it came out on direct examination that he said on direct, after 30 days, there's no history of FaceTime records. So had it just been left at that, would you still be raising the same claim?
I think if the Commonwealth had not focused on this, it would have been less important.
So the problem is the
trial.
Cross-examination, and
the closing.
again, maybe less so, but the cross-examination I think goes to the heart of it. So again, I'm having trouble seeing how it's deficient to not rebut that, to not counter that cross-examination with an expert versus some other evidence.
Well, like what, Your Honor? Other evidence
like the
what?
policy that they could have put in.
Okay, so it was ineffective assistance for the defense to do nothing to not anticipate it and to do nothing to counter it. Maybe there's other things beside an expert that they could have done. Maybe they could have submitted Apple's policy if they properly authenticated it. I don't think that makes any difference. I think what's important is that what they did, or more precisely what they failed to do, was ineffective.
But that's not the claim. I mean, she wasn't asked about that at the hearing. Why didn't you put in the copy of the policy?
Well, Your Honor, I don't, they did not, they said they didn't think about doing anything to counter the gap. And to me, the fact that they could have done something else does not detract from the essence of our claim. They should have put on an expert. It would have blunted the cross. It would have corroborated his testimony in a credibility contest case, and therefore that was ineffective assistance. Thank you, Your Honor.
All right, thank you. Good morning.
Good morning. May it please the Court, Helly White, Spate, Assistant District
Let's
Attorney.
just wait a sec till we get the clock reset. Yeah, there we go.
Sorry.
Okay.
For Middlesex, on behalf of the Commonwealth. Before we get into the merits of the defendant's arguments, I want to flag something that's in the defendant's reply brief. I almost never discuss them. But it looks to me as though on pages 5 and 6 of the reply brief, the defendant is asking this court for de novo review of the judge's ruling, and that simply is not the law.
Well, you agree that the motion judge was presented with two witnesses, the expert and the defense trial counsel, appeared to credit what they said.
Yes.
And otherwise, we are in a position the same as the motion judge to review the trial record. So even if it's not exactly de novo, it's pretty...
It's abuse of discretion, Your Honor. And that is not the same as de novo review.
So even if the motion judge is in no better position than us?
Yes.
Is it abuse of discretion?
Even
because I looked at the
where-
cases that defense counsel cites, and
That doesn't make it de novo.
they're kind of, you know, the SJC will say two things in a row and not necessarily try to reconcile them. Don't quote me on that.
Nor me, but I don't disagree with that. Look, abuse of discretion means that this court decides not whether it might have decided it differently, but whether the motion judge's decision was outside the range of reasonable alternatives. So that's very different from de novo review. Certainly when you're looking at the trial record.
But where the judge says this wasn't manifestly unreasonable, yet defense counsel says at the new trial hearing, we never thought of this. Isn't the motion judge applying a strategic decision standard that really is inapplicable where no decision was made?
No, I think a decision was made. I think if you read the motion judge's ruling, the essence of that is counsel says we didn't think of this, but counsel clearly did some research on it and decided that this was
research on
not.
whether records were available, not thinking of an expert or some other way of proving that records would not be available regardless. That's something that counsel says we never thought of.
And the
So how
motion
can that
judge-
be manifestly unreasonable?
And the motion judge who heard the testimony, who heard the expert, who heard trial counsel testify, concluded that this was, if perhaps a lapse, not a manifestly unreasonable one. And this court defers to that finding.
I don't know if the judge concluded that. It's a little bit ambiguous to me. It seems the judge concluded he wasn't deprived of a substantial ground of defense. Isn't that a conclusion of law?
I think it's dependent on the facts of the case.
Whether something's a substantial ground of defense is not a conclusion of law.
I think it's a mixed question at best.
It's an error of law. That's an abuse of discretion, right?
What I'm saying is this court still defers to the motion judge.
I mean,
This court gives special deference, the cases say, where the motion judge was the trial judge. But even where the judge denies the motion on the papers without holding any hearing at all,
but then what does it mean?
it's abuse of discretion.
What does it mean when the SJC has said many times that the appellate court is as good a position to evaluate the trial record if the motion judge was not the trial judge? What does that mean?
What that means is when it comes to a decision as to whether the motion judge's decision is supported by the trial record, you're in as good a position to evaluate that as the motion judge.
Okay, so we look at the trial record and we decide whether this was whether performance deprived him of otherwise available substantial ground of defense.
I think that's the
Okay,
the
so
crux of the argument
let's
here.
talk about that.
I just wanted to flag that because things like that can often work their way into decisions in ways that can take a long time to undo. So the question, I think the question, we can ignore all other questions and get to, was the defendant deprived of something material? Would better work have accomplished something material for the defense? And I think the answer to that, taking that word material seriously, is no. There is nothing that the Commonwealth would have been prevented from doing or saying, either in the cross-examination or the closing argument, that would have been precluded by the testimony
Well, but
of
is
an
that
expert.
the standard? I mean, not that it necessarily have been precluded, but wouldn't it have blunted the effect of that cross-examination and the closing if defense counsel could say, you heard why there are no records. You heard Apple dumps them after 30 days. He didn't even know for more than 5 months what date it was supposed to have been. Of course he couldn't find any records.
But the question would, but the fact would remain that there still were no records. It would not have contradicted the possibility that the defendant had gone into his phone and gone into his computer and deleted all the logs. That would still have been something that he could be asked about. There still remains the fact that there is no record. The only thing that is blunted is whether the defendant could have produced records. Even if some expert could have said, yeah, I went into his cloud and I found a FaceTime call. We now know that the only thing Apple ever retained would have been the time that call was initiated. Nothing about the duration. Even if we had a record, which we now know it doesn't exist, that a FaceTime call was initiated, was accepted at 11:50 p.m. and continued until 2:20 a.m., we still, unless we have a recording of that call, which shows us the defendant's face throughout.
I don't think you need to go that far with your argument. I mean, I think to the reason for the record's unavailability would have on the cross-examination of the defendant.
I understand that, but I still don't. I think it perhaps shortens that cross-examination somewhat, but only if the expert has testified before the defendant was cross-examined, right?
Well, presumably, I mean, we're now 3 hypotheticals into this world in which this happened, but they would have structured it.
That's part of the problem, I think, that this is not a case where there's some palpable benefit beyond the extremely marginal support for the defendant's credibility.
The prosecutor chose to ask questions on cross-examination such as, you're not a representative from Apple, are you? So you don't know how long they preserved the records.
Right, and
so
the prosecution still gets to ask those questions.
Well,
okay, but
might have been not a very valuable question if the expert had testified first.
Then if the expert testifies first, yeah, the question is less effective, certainly. But this is getting into the realm of somewhere far beyond the ordinary fallible lawyer. To say, or we are not beyond the ordinary fallible. We are still squarely in the realm of the ordinary fallible lawyer. To say, with this one thing that the defense didn't anticipate being asked, that this sufficiently cast doubt on the justice of the conviction.
I don't think it's fair to say they didn't anticipate it being asked because defense counsel testified at the motion for new trial.
Right.
I looked. I found the Apple policy. And I decided, well, I can't get the records anyway. So that's actually a decision. It's not a failure to consider.
No, it's what I think the defendant's argument is, and I think what counsel, I believe this is an accurate reading of her testimony. What counsel testified was, we didn't anticipate the Commonwealth making such a big deal of this. I knew I couldn't get the records, and I didn't go further because the records, even if we could have gotten them, wouldn't have supported the alibi. And certainly the fact that we couldn't get the records wouldn't support the alibi in any respect.
So that's more like a strategic decision, in your view?
I think so, yes. And I think the motion judge's findings suggest that as well.
What's the basis for the question, would you be surprised to know that the FaceTime logs remain far after 30 to 90 days?
That's a very good question, and I don't know.
What's that?
I don't know what the basis for that was.
Okay.
Does the basis
had it been
need to be-
objected to, the objection might have been sustained. But again, this is something where we had two defense attorneys, both highly experienced and very competent and able, as the motion judge found.
So there's no objection to that question.
Suggests that,
And Cross goes on for about five pages about this issue of records. The clear implication is that he's lying.
and there's no.
And you don't
but
think
there's-
you don't think a competent attorney would have tried to counter that in some way?
No. I mean, yes, there are attorneys in the universe who might have tried to counter that. The question is, would that be a material benefit to the defense? Is this imperfection, or is this incompetence beneath the level of an ordinary fallible attorney?
This is the very defense, right? That they knew this is the defense they're presenting at trial. So wouldn't you do everything to try to get confirmation of whether there's records, or, wouldn't you have done something?
That's an argument for perfection.
Well, counsel's saying...
And we don't expect perfection. We
Is
look
it
for-
really? The counsel, what do you say to counsel's point? There are two clear weaknesses in the defense. One is there's no record of the call.
Mm-hmm.
Second is there's no explanation for no record of the call. In these days, it's kind of like the Commonwealth, a reverse CSI effect. So, you can take that out of the case if you have an expert. Why isn't that something material?
The only thing you can take out of the case is there's no accounting for the lack of a record. That's the only thing that takes.
There's no what, I'm
No.
sorry?
There's no explanation for the lack of a record. That's the only thing you can take out. You can't take out there isn't a record. And I think,
But isn't that, one of those 2 points material?
no, I don't think so. I don't think that second point is material. I think.
How do we decide what's material? What objective standard do we use?
I think we look at the evidence as a whole. We certainly look at the motion judge's findings. We look at the motion judge's assessment of counsel's testimony.
Doesn't
And we ask
materiality
ourselves,
mean...
just as we always do, was there a substantial risk of a miscarriage of justice? This is an omission of defense counsel, and so you look for a substantial risk of a miscarriage of justice. It's the same standard. And I don't think you get there with this case.
So if the jury believes that the defendant is lying, that he was on this FaceTime call, because it can't produce any corroboration of it, that sinks his defense, right?
The jury can still believe he's lying about being on the FaceTime call, even if it turns out.
I understand that, but
be
when
true
we're
that he
talking
can't
about
produce a
whether
record of it.
something's material,
Where there's still not a record, there's still not anything to support the alibi. And that is what distinguishes this case from all the cases the defendant
when you
cites.
have a prosecutor who cross-examines him about the lack of records for some time, and the implication is that he's lying, if the jury believes that, that sinks his whole case, right?
It sinks his case if the jury believes he's lying about the FaceTime call.
Right, and why would he be
Or
lying?
not.
What
the
evidence?
jury can believe he was on that call and still convict him.
What evidence is there that he's lying about the FaceTime call, other than the implication from the lack of the records?
Well, the jury gets to see him
right,
testify and gets to decide who they believe.
Who do they believe? But in terms of whether he's lying about it,
The question is not, and again, the question is not whether he's lying about the call.
Well-
that is not affected by whether those records could have been obtained or not.
That's the implication from the cross, is that he's lying about the call. That's my point, right?
But the question is whether he's lying about whether he could, about being able to produce a record. And I don't think there's any argument that the Commonwealth would have been precluded from making based on what the expert or the policy or whatever additional evidence should have gone in.
So is that what materiality means?
Materiality means, does this court have serious doubts whether the outcome would have been different?
Right. Did it move the needle?
No,
Or could it have moved the needle?
no. I say no.
All right. Thank you very much.
Thank you, Your Honors.
And our third case will be, and we will be taking a short break, 15-minute break or so after the third case. I believe it's 23P691, John Doe number 526442 versus Sex Offender Registry Board. Good morning.
Good morning. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. I'm here today requesting that this court lower my client's classification level from a level 3 to a level 1 or remand the case back to the board for another classification hearing. The level 3 classification of my client, the decision was arbitrary and capricious as there was insufficient evidence to find by clear and convincing evidence that my client poses a high risk of reoffending or degree of dangerousness. My first argument is that the hearing examiner erroneously denied my client's motion for expert funds. An expert was needed in this case because, as you'll see from the record, my client was in fact diagnosed with depression. His mother testified to that effect, and also there was a 2018 evaluation form that was submitted into evidence by the board indicating that he was diagnosed with depression and that he was
So could I ask you about that? So when I look at the motion, I think there's only one, right?
Yes.
It doesn't say anything about his depression diagnosis, and the hearing examiner doesn't address that in their decision. So
Yeah.
how is that a preserved issue?
So during the testimony from my client's mother, the attorney who handled the hearing did actually evoke that as an issue when he was, also even before the testimony, he also brought it up as an issue when he was arguing the motion for funds. So he brought it up as he was arguing the motion for funds. He brought it up as he was examining the mother, and also in the motion for a new trial that he, motion for judgment in the pleadings that he filed in the Superior Court, he also brought it up as an issue. He didn't spend a lot of time.
What do we do about the fact that the hearing examiner apparently did not think the issue was before them?
I mean, the attorney who handled the hearing did bring it up as an issue. So I would say there was an error on the hearing examiner's part, not actually even addressing that, the depression as an issue in terms of getting funds for an expert. It was the board actually that submitted the 2018 intake form into evidence. And within that form, the person who evaluated my client did find that he suffered from depression. And because of that, I think that it would only be fair for my client to have expert funds in order to hire somebody to actually do an evaluation to update the 2018 evaluation, because in that evaluation, the person who evaluated him also administered the static 99R, which is a risk tool, and finding that my client poses a more than moderate risk of reoffending. So that was 2018, and so my client should have received funds from the board, received funds from the board to be able for him to hire his own expert to replicate that test that was done on him, to update it as well, because the hearing was in 2020 and he was evaluated in 2018. So for these reasons, I would say that the case should be remanded or his level should be decreased to a level 3. I'm sorry, to level 1 from a level 3.
Do we have, you mentioned that it was argued at the motion hearing that your client's mental health challenges were a basis for the request for expert funds. Do we have that motion hearing in our record?
So it was argued in his, in the memo that he submitted for the motion for, let's see, it's on volume 2, page 120. excuse me, the attorney does mention that my client suffers from psychological history strongly for the need of independent examination by a qualified expert. So he does make that argument in front of the Superior Court.
The Superior Court, right? But I think the bigger issue is whether it was raised before the hearing examiner. Can you give us a
Yes, I can.
citation to where it was raised?
Yes, I can. Volume 1, page 59, he does bring up the fact that the board submitted the 2018 eval into evidence, and within the 2018 eval, they did perform the static 99R, and so because of that, he should be able to get funds in order to do another one. So that, again, that's volume 1, page 59. It's right the first paragraph on that page. And I will also argue that the hearing examiner erred by finding that the girl was a stranger. If you look at factor 7 within the regulations, a stranger, if the person's online and the person's considered a child, they're considered a stranger only if the offender transmits, and I'm quoting, sexually explicit materials or makes sexually explicit comments within the first 24 hours of the contact. Here, there was nothing submitted into evidence indicating how long my client was in contact with her via Facebook. In addition to that, no one submitted anything indicating the content of that communication. So we don't know how long they were in contact. It could have been a month via Facebook. I have no idea. There was nothing submitted into evidence. And then the content of that communication, again, nothing was submitted into evidence. So we have no idea what they were communicating about via Facebook. So because of that, I would say it was error for the hearing examiner to apply factor 7, indicating that she was a stranger.
If we agree with you that it was error, how do you respond to the board's argument that didn't cause any prejudice because she clearly would have been an extrafamilial victim?
I would say it did cause prejudice for a few reasons, but one of the biggest reasons is that my client's only been convicted of one sexual offense, and that was in 2016. The hearing examiner used the fact that she found the person was a stranger to increase his risk of reoffending. I mean, it would fall under extrafamilial, which is still not, still increases it a little bit, but not as much as if she were a stranger. So I would say because of that, and also because of the error regarding not allowing funds for an expert. So I think it could have tilted it in terms of the hearing examiner finding that my client posed a moderate versus a high risk of reoffending. I think the mistake was that big.
When is the soonest that your client could apply for reclassification? Is that, I know there's a 3-year period, but is that told during the pendency of this, or?
Very good question. So I did look at the timeline, and it's kind of concerning that it took 2 years from the time the decision was issued until the time it actually made it to the Superior Court, and then that decision was issued by the Franklin Superior Court. So 2 years had already elapsed, and then I filed the appeal here, and the appeals take a while sometimes. So he's able to file for it now. But I still would assert that even though he could have filed for it now because 3 years have passed, I still think this court should address these issues and remand it if you feel that it's necessary to remand. Because just because he could apply a motion to have it lowered in front of the board now, these issues are still live issues that I think, should be rectified.
And if I'm right, if you petition for reclassification, if you make some threshold showing that something has changed, then the board has to reprove its case again by clear and convincing evidence?
Yeah, they could make a decision prior to a hearing, and if we're not happy with the decision, they could lower it to a 2 or lower it to 1 or leave it the same. If we're not happy with it, my client could appeal it again and then get another hearing in front of the board. So yes, that would be the procedure, and that's what I've advised my client to do, and if we lose here. So in addition to the error with factor 7, I also would argue that if you read the regulation for factor 32, sex offender treatment, that's a risk mitigating factor. The hearing examiner gave my client moderate weight for that instead of full. And I would argue, and just semantics is important when you're writing regulations. I would argue that the hearing examiner should have given my client full or threshold application of this risk mitigating factor, because there's nothing in here indicating.
Full and threshold are two different things, aren't they?
Yeah, I mean, so I would say, full, like the most he could possibly get under this. The fact that he didn't have to be actively involved in sex offender treatment, and he was. And the fact that he had recently started it should not be used against him, because it's the board who
Well,
decides.
it's not being used against him, but it's just being used to moderate the amount of
Yeah.
credit that
Yeah.
he gets for it. If he'd
Yeah.
been in it for
Yeah.
3 years and
Yeah.
gotten, completed various steps, presumably he would have gotten more mitigating weight from it.
Or even if the hearing would have taken place maybe 6 months down the line versus when it took place, he would have gotten more. And I think like with the different errors that I talked about, if you add just a little bit of more risk mitigating impact or weight on this, that could also make a difference.
Doesn't Factor 32 say expressly that the risk mitigating weight given depends on how much progress the offender has made in treatment?
So if you look at 32A2, which is the currently participating in treatment, it says under what conditions the person could get more credit. It doesn't say when they could get less
Right, but
credit.
if you read above number 1, it says the risk mitigating weight varies in degrees based on the following: completion, currently participating. So why doesn't that directly support the hearing examiner's decision?
I personally think it's unfair for the board to decide when to have the hearing and then not give a person full credit for the risk mitigating factor based on the timing of when they decided to give the hearing. Again, the hearing examiner wrote relatively new to treatment, so that was the reason why. I I would admit that this isn't as strong of an argument, but I do think that the language in the factor is a little bit confusing, and I guess felt that it was kind of used against him in a way, that he had recently started, and it wasn't his fault in terms of when he started or when the board had the hearing. And just lastly, I would just argue that my client, if he poses any risk, would be a low risk to reoffend, and danger to the community. As you know, he was pretty young, 20 years old, when he committed his only sex offense that he was convicted of. I mean, he's still young today, but pretty young. And that was in 2016. Again, it was only one sex offense that he was convicted of. If you look at his CORI, he has a very minimal criminal convictions. Many of the charges were brought when he was a juvenile, and all of them were actually dismissed while he was a juvenile. He hasn't reoffended since he was released in 2020. He's very active in sex offender treatment still to this day. He'll be on parole. I'm sorry, he was on parole, and now he's on probation. He'll be on probation till 2026. His home situation is a very positive one. So factor 33, risk mitigating factor 33 applies. He resides in a very supportive home environment and has 11 support and many family members and friends.
But just as a practical matter,
Yes.
wouldn't applying for reclassification get you just as much, if not more, than a remand? I mean, because the reclass can take into account all the current circumstances.
Yes.
Does a remand take into account all the current circumstances, or does it just look at whether the classification was
So that is an excellent
correct.
point, and that's something that we have discussed. We chose to continue with this appeal and, see what happens, and then file a motion for it to be lowered.
But you're not,
Class.
you agree that applying for reclassification can get you a fuller review of his current circumstances
Yes, I do.
than could a
Yes.
remand?
Yes, I do.
Okay. All right.
you
Seeing
so
nothing
much.
further, thank you for your argument.
Thank you.
We'll hear from the board.
Good morning. If it pleases the court, David Chennai for the board. I think the plaintiff's argument, the strongest argument they have is the Factor 7 application. I think that I'm not giving up on my waiver claim, but even if you make this individual an extrafamilial victim, the facts clearly dictate the level 3 classification based on this individual's behaviors during that time period. While he had the sex offense cases pending, there were numerous problems that he had with other teenage girls. And also he had a domestic assault and battery during that time. So in 2018, which is when these occurred, 2 years prior to the hearing, he appeared to be someone who was somewhat out of control and exhibiting sexualized behaviors towards teenage girls. So I think the level 3 in 2020 was more than fair. And unless you have specific questions, I'd be more than...
Since you said you're not giving up on your waiver claim, I'm going to ask you a question about it. Do you have a case applying waiver based on failure to raise an issue before the Superior Court as opposed to the hearing examiner?
It's always been in front of the Superior Court because the idea is if you have a hearing in front of a hearing examiner and you don't say raise, because you can't raise an issue that you misapplied Factor 7 because...
Right, but you can raise things like, you can waive issues like on a motion for funds or
Correct.
an evidentiary issue.
Right,
But
if you don't
the cases
file
you
those.
cite, I looked at them, they do not involve a failure to raise an issue to the Superior Court. And I'm just wondering how, if you have a case, A, do you have a case, and B, how does that make sense when we're reviewing de novo anyway?
Well, I think that it makes sense in the sense that they should raise the issue down below. It shouldn't have to come to this court to be litigated. You should be looking at what the Superior Court decided on the issue. I mean, it's judicial economy more than anything. So I think that because it wasn't raised down at the lower level and the judge at that level didn't have the ability to rule on that, he may have sent it back or he may have agreed with the board that applying 7 the way it was applied may or may not have been harmless. So, but we could have had that resolved in the Superior Court. And then, although you look at these cases de novo, you still have to give discretionary deference to both the Superior Court and the hearing examiner's decision.
No, I don't think that's right. We don't give deference to the Superior Court's decision.
Okay, well, you still have to give deference to the hearing
That's
examiner's
right. That's why I'm
decision.
asking whether there's a case that says it's waiver if you don't raise it to the Superior Court as opposed to the hearing
I don't have
examiner.
the site with me, but it's in my brief. It's a Sorb case, actually, that issues not raised in the Superior Court are deemed waived, and I have it written right in my brief.
Okay.
Would you agree that, number one, that Doe's eligible to apply for reclassification now?
Yes.
Okay. So there's no blackout period for when you have a 30A judicial review proceeding pending?
I don't understand the question.
I thought at some point the rule was you can apply within 3 years or when you no longer have a 30A proceeding or appeal
Correct.
pending.
If there's a case pending, you don't have a decision, a finalized decision that you can then ask for a reclassification from.
So the pendency of this appeal means he could not apply for reclassification
Correct.
now?
Correct. The pendency of either a 30A or an appeal prevents an individual from asking for a reclassification.
Do you happen to have that reg site?
I'm
Must
not
be in the
positive
reclass reg.
I'm not sure which reg it is, but that's pretty much in the rules, in the regulations, specifically directed as to, and actually I think it's also part of the statute, that you can't, because the idea is that you have to have a final classification decision to be able to ask for a reclassification from.
But then the petitioner doesn't need to wait 3 years from that date, or do they? In other words, does it toll the running of the 3 years, or does it
It
just?
does not toll it. The
Okay.
minute this case is, if this individual had dismissed the case prior to coming here after June 21st, he would have been eligible to file for a reclassification.
And so he's still eligible after June 21st, which is to say now, except for the pendency of this appeal?
Correct.
And if he did apply for reclassification, would that get him a fuller consideration of his current situation than would a remand?
If you remanded the case, unless you ordered a new hearing, the board would write an amended decision. It would then go through the...
And is that decision looking at what how he should have been classified 3-some years ago, or does it look at how he should be classified today?
That would be based on 3 years ago and the actual issue that was raised and rectifying that issue. To do an updated one, he'd have to have a new hearing. And again, if he filed for a reclassification, he would get a full hearing where he could bring in witnesses, he could request an expert, he could bring in any mitigating evidence that he has, and he could effectively, again, challenge the board's evidence and make arguments such as a lapse of time in the community offense-free, aging, those kind of issues. He can't raise them on a remand where they were just doing an amended decision because it's not a new hearing.
All right. Seeing no further questions, thank you both for your arguments, and we will take a 15-minute recess.
Order all rise, please. Let's speak. All right, we ready to go?
We're ready, thanks.
Madam Clerk?
Okay.
Audience, ready? Court, all rise, please. Court is now in session. Please be seated.
All right, calling our fifth case, 24P52, Sally Wynn versus Diane Delori, and we're hearing only from the appellant this morning.
That's right, Your Honor. Thank you all very much. May it please the court, and good morning. And I'd like to thank the court for allowing me to have my associate, Mahmoud Hassan, at counsel table while he anxiously awaits the results of his bar exam. I'm going to first, with the court's indulgence, address some of the key procedural aspects of the case that I think bear on its decision. Then I'm going to address the Superior Court's error in failing to dismiss counts 2 and 3 of the amended complaint. And I'd also like to discuss...
About 1?
I'm sorry?
How about count 1?
Counts 2 and 3 of the amended complaint filed by the...
I think we're asking about count 1.
Oh, count 1. Well...
Yeah. But let me back up for a minute and say perhaps I'm not sure if you were here at the outset, but we've read the briefs.
Sure.
We know the record. We know the procedural posture, so we'd urge you to get right to the heart of your argument.
Okay. Well, essentially, the appellee has filed, she filed her original complaint in May of 2022. That complaint was dismissed for want of hitting the jurisdictional limit for damages. It was a 2-count complaint.
I don't understand how the motive in adding the slander counts goes to whether this is a slap suit or not.
The motive in adding the slander count?
Yeah,
Well,
that's an argument you make in your brief, and I don't know where motive comes into the analysis. I mean, particularly
motive may
after
not come into the analysis,
particularly after the Bristol asphalt.
Right. Well, no, understood, Your Honor. And the reply brief was filed, actually it was pending, the appeal was pending when Bristol asphalt came out. But it does certainly demonstrate a determination on behalf of the appellee to avoid the dictates of the anti-SLAPP motion to dismiss. She added those 2 counts, in particularly to try to get around the anti-SLAPP motion, which was pending at the time.
But a judge is supposed to go claim by claim. So even if 2 and 3 were to survive, you still have to deal, and the judge should have dealt individually with counts 1 and 4.
Right, and I think what the judge did was the judge said, well, because counts 2 and 3 survive, I don't have to get into counts 1 and 2. Counts 1 and 4 were clearly based upon petitioning activity.
Well, 4 is based on everything.
I'm sorry?
4 is based on everything that came before it, which in the amended complaint includes claims 2 and 3.
That's right.
So it seems like, it seems as though claim 4 rises or falls with the other claims.
That's exactly right, Your Honor. Yes, it does. So the initial complaint, of course, and her claims are that the appellant made defamatory statements to the Newton Police Department in reporting that she swerved towards her. And that set off, you know the rest. The police department reported it to...
So, I mean, I think a key question here is how is the statements to the, how are the statements to apartment complex management petitioning activity?
Well,
particularly where there's, I don't see anything in the complaint alleging that she did that because she wanted management to evict the plaintiff.
Well, her complaint actually states, Your Honor, that particular count, she asserts on information and belief that, quote, the defendant subsequent to the date of September 14, 2019, on diverse dates and occasions, made defamatory statements to the management office at her residence, the Avalon. So first, the Superior Court should have taken notice of the fact that she tied it to her residency at the Avalon.
Right, but we construe the complaint in the light most favorable to the plaintiff. We don't, certainly the plaintiff is not going to concede that and didn't concede in her complaint, that the defendant went to apartment management and said, look at all the bad things she's doing, can you please evict her because she's really bothering me and the other tenants around. And you might have a stronger case that that's petitioning, but where there is no demonstrable nexus between between complaining to management and the management's subsequent filing of a summary process action, how can we say that complaining to management is petitioning? That's to a private entity.
Your Honor, I would say for the first part, the fact that she ties it to her residency means it was well outside the 3-year statute of limitations. So the court should have dismissed this on 12b-6.
That's not before us.
It is before you because the court based part of its decision on its denial of that aspect of the motion to dismiss.
Right, but it's not the whole motion to dismiss.
No, absolutely
It's not the 12b-6. It's just the anti-SLAPP motion to
Right.
dismiss.
That's what's before us, but also the error on the 12b-6.
How's the 12b-6 before us? This is an interlocutory appeal, right, from the
That's true.
denial of the anti-SLAPP.
True, Your Honor. Because I think in part because the court didn't get into it as deeply. But regardless, let me address we had submitted to the court, and I don't think the Superior Court considered the notice to quit dated May 14, 2019, which is in the appendix 2, page 44, the docket we submitted of the eviction proceedings, and the no trespass order obtained by building management in the fall of 2019. And the statements in the notice to quit, which was drafted by counsel and started the legal process of the eviction proceedings, it provides a glimpse in almost word for word in many parts the allegations of the complaint against my client. So
But how does that make what your client said to apartment management into petitioning activity? You talk about the Blanchard case where the hospital's statements to the Globe had a plausible nexus to petitioning activity because there was a high likelihood that the statements to the Globe would be published and therefore influence or at least reach the relevant state agency.
Well, Your Honor, I think this is very close to Hanamura, actually, where the doctor's statements in records had a close nexus to what could have been and what turned out to be proceedings, child protection proceedings for a child. This is a doctor who made statements in medical records, reports of what the child stated, what the parents stated in an interview. And here we have...
But the reports went to DCF, right?
Not by the doctor. The doctor made his statements in the medical reports, then they were sent to DCF, not by the particular doctor, though. So the question in that case was whether the doctor who was being sued for defamatory statements made in the medical records in Hanamura, whether those statements in the medical records were protected, right? And in our case, we have statements made to building management which were used in eviction proceeding. They were made to management, and we have submitted the evidence of the notice to quit letter, which started the legal process, which set forth the litany.
But the physician in Hanamura was a mandated reporter, I have to assume. And your client, while she has every right and perhaps reason to complain to management, is not a mandated reporter. So isn't that a significant difference?
I think it's a difference, Your Honor, but not for the purposes of an anti-SLAPP discernment here and in consideration. And that's because the question is, was there a plausible nexus between the statements at issue and petitioning activity? And here, clearly, these were statements that were used by counsel in drafting the notice to quit, right? The notice to quit has the entire litany of wrongs that the appellee engaged in when she was a tenant at the Avalon.
Does it matter whether your client actually asked the management to evict her or wanted that? Or is it sufficient that she provides information to management and then management completely independently says, let's evict the plaintiff, and goes ahead and does it?
Great question, Your Honor. I don't think it is relevant. And again, we go back to Hanamura, where I don't know that the doctor, in making his medical notes in the records, the medical records, whether DCF eventually uses those notes to pursue an action against the parents, or whether they're discarded altogether.
The complaints from the other tenants, that's petitioning activity too?
The complaints to the other tenants,
From the other tenants?
or from the other tenants. I'm sorry, which complaints? You
Any complaints? Complaints from other tenants about her behavior to management, that's also petitioning activity?
It would depend on the circumstance, Your Honor, but certainly a building manager like my client who had an obligation as a matter of her job to bring these matters to building management, I think that creates a stronger bond and a stronger relation, and certainly we see what happened here. There was a notice to quit, and the notice to quit has all of the allegations of wrongdoing by the tenant, by the appellee when she was there. That was eventually used to evict her that summer and to trespass her from the property. So clearly we have the legal process. We have statements that an employee, a management level employee at a building made to her superiors and to counsel that were then used and set forth in the notice to quit.
She was management level? I thought she worked at the front desk.
She, supervisory, I'd say. I'll make a distinction between someone who's supervisory, who tenants would make complaints to her. She was the voice in the spokesperson, in the conduit of information to the decision makers at the building. So
I know you've cited Hanamura a couple times. That's obviously not an appellate case. Do you have any appellate cases that stand for the proposition that getting the ball rolling on what turns out to be a legal proceeding is petitioning activity?
Well, Your Honor, I'll have to rely on the brief. I know we addressed it in a couple of different places in the brief, not immediately to mine, though.
So if your client had made the same statements to management that she's alleged to have made here, and then management, instead of filing a summary process action, just went to the plaintiff and said, look, you're generating a lot of complaints, let's move you to another one of our buildings, and we won't have to go through a summary process action. So it never leads to any petitioning activity. Does your client still get this case dismissed under the anti-SLAPP statute?
Well, I guess the question is there a plausible nexus to, when the statement is made, certainly it is a clear possibility. I just don't know the answer to that question, Your Honor. It's a great question, but it didn't lead to petitioning activity in your example, but it did lead to petitioning activity.
I would think your answer would be it wouldn't make a difference, because you're saying that these statements are petitioning because they're reasonably likely to reach a governmental body. So it'd be the same. I would think your position would be the same whether or not management filed an eviction proceeding.
I think it would be, because that is the direction certainly that it went in this case, and it could go. And that's the direction it went in Hanamura as well. That, who knows if the doctor, when he made these notes in the chart, was aware that they would be used or could be used in the child protection case. My client may not have known if she made these statements, and again, these are allegations, what building management was going to be doing with them, but certainly they did lead to legal process. They did lead to a notice to quit and eviction proceedings.
So let's say I'm walking down the street and I see a car accident, and someone calls the police, and as an eyewitness, I'm interviewed, and what I saw shows up in a police report, and then there's a criminal complaint or, failure to stop or reckless operation or something brought as a result of the accident, and I'm called as a witness at trial. Is my initial statement to the officers as an eyewitness, is that petitioning activity?
I believe it is, Your Honor, yes. I believe you make a statement to the police, and the police have asked you, right? People just don't randomly make statements to police. They report accidents to the police. They respond to police queries and police inquiries. And I think we certainly want to encourage citizens to cooperate with the police and provide information on things like accidents or criminal occurrences. And I think if we didn't, and these people were exposed to lawsuits based upon allegations that the statement was false or the statement caused emotional distress, I think societally that's just not a good thing.
Count 3, could you address that briefly? Are you saying it's petitioning because the statement was to the court officer? Or you're saying it's petitioning both because of that and the content of this statement? I mean, does it matter what the statement was?
Well, I think the former, Your Honor. I think it's significant that her allegation, and again, we deny the statement was made, but regardless, the allegation is that she made the statement to a court officer at the beginning of a trial. Had she made the statement to a stranger on the street, had she made a statement to perhaps a visitor in the gallery, it wouldn't hold the same weight.
So she could have said something inflammatory against the plaintiff to the court, and because it's to the court officer, it's still petitioning?
I think it is, Your Honor. I think that there's a plausible nexus because a court officer is someone we all know communicates with the court. They're in the courtroom, they watch the proceedings, they play a very important role in our system. And again, if she had made this statement, allegedly made this statement to a stranger in front of the courthouse, to a visitor watching from the gallery, it would not have held the same weight. But she alleged that the statement was made to court personnel. And I think that is very important, and I think that does form the necessary nexus, a plausible nexus, to the activity, which is close in time, right? They're about to start a trial.
Okay. All right, thank you very much. The appellee has submitted on brief, so we'll take it under advisement. Thank you for your argument. And our final case for the day will be 23P830, Smith versus Armstrong. And I believe there's some impounded information in the case, so I'm sure counsel are cognizant of that. So, Attorney McBrien?
Yes.
Yep. Everybody.
Good morning. May it please the court, my name is Maureen McBrien of Brick, Jones, McBrien, and Hickey. I'm here with my partner, Alex Jones, representing the appellant here, Justin Smith, and the plaintiff below. We're here seeking that Your Honors vacate paragraphs 1, 2, 3, and 9, which are alimony and child support provisions only of a modification judgment dated May 31st, 2023, issued by Judge Kimberly Moses of the Norfolk County Probate and Family Court. Your Honor, this was a post-modification filed in...
So we've got the background. Let's jump right to the issues. You mentioned failure to consider tax consequences.
Yes.
The mother argues that the father didn't introduce any evidence of the tax consequences. What is your response to that?
So my response to that, Your Honor, is that requirement was as of the Kavanaugh case on August 8th, 2024. Child commenced August 30th, 2024, and there was no mention of a CPA testifying until the request was made by mother on the very first day of trial. Over by objection, the mother did have a CPA testify who did introduce tax consequences of an alimony obligation. His name was Rich McKenzie,
Yeah.
and the judge didn't even mention him or discredit him in any manner in the judgment. And there were also tax returns that showed the parties' effective tax rates and marginal tax rates in evidence as uncontested exhibits.
But you haven't really, I don't see the evidence that the father introduced that would have obtained a more favorable result if the judge had considered tax consequences in a particular way.
Well, I think she just got the entire premise wrong that alimony was non-deductible and non-includable, and that rendered all of her analysis incorrect. So they did get divorced prior to the Tax Cuts and Jobs Act in 2018, and expressly in their separation agreement.
Is that
alimony
because
was-
of some delayed effective date? Because the judgment nisi was in July of 2018, and I thought the act was passed in maybe January of 2018, or effective January of 2018.
It was effective January 1, 2019.
Okay.
So their obligation was tax deductible to the father and included in income to the mother, but the judge got that entirely wrong in her equitable order analysis, where she stated the opposite, that there were no tax consequences to consider because they were divorced after the Tax Cuts and Jobs Act, such
Okay.
that it was...
So what should the judge have done differently?
So the judge should, one, she should have made alimony calculations under step one, which she did not do. The alimony
No,
calculation...
but specifically about tax consequences.
About tax consequences, she should have, well, one, in the retroactive award, she simply, for alimony, she simply did a math calculation of the delta of what he paid and what he should have paid, without taking into consideration that what he paid was tax deductible and includable, such that the number was before taxes rather than after taxes. So he was ordered to pay $66,000 in retroactive alimony, but since he had already paid alimony, it was deductible and includable, you needed to tax effect that number down by his tax rate to get to the actual amount he would pay her in retroactive alimony. So that was one, so it was arbitrarily inflated.
And was there evidence of how much that would have been? That was specifically called to the attention of the judge?
There were tax returns in evidence, which you can apply the father's tax rate each year in question as uncontested exhibits to determine the net after-tax amount of the retroactive alimony award. So there was evidence on that. Your Honor, but Kavanaugh's three-step framework that the judge did attempt to apply, she was probably one of the first judges who, after a trial, had to try to apply Kavanaugh, which has been confusing to not only judges but also practitioners. But when she did her step one, calculate alimony first, and then calculate child support using the parties' post-alimony incomes, she created a few errors. One, she didn't make alimony calculations. She just picked a number that was quote-unquote appropriate.
What kind of calculations are you saying she should have made?
So under General Law, Chapter 28, Section 53B, you have to take 30 to 35% of the difference in the parties' gross earned incomes at the time of the order being issued, or the need of the recipient.
Do you dispute that if she had done that, it would have resulted in a higher alimony award?
I dispute that only because she included components of the father's income in such calculations that the parties expressly excluded in their separation agreement to be considered in any future alimony calculation, including income from a gifted asset from his father.
But the mother says that, and has math in the brief that seems to support it, that even if all those items you say should have been excluded were excluded, the rate still would have been well within the 30 to 35%.
That analysis
or
does,
well below, excuse me, the 30 to 35%.
right. That analysis doesn't take into consideration child support that was paid. It just takes the parties' incomes. So that was one discrepancy there. You have to look at the issue in conjunction with the underlying child support order as well. And also, it's not that always judges just take 30 to 35% of the difference.
I'm sorry, can you back up?
Sure.
How should she have considered the child support under Kavanaugh Step 1?
Under Kavanaugh Step 1.
We're talking about Kavanaugh Step 1, right? So how would the child support have factored into that calculation?
So you have to then run child support using the parties' post-alimony incomes. So the alimony calculation is made, which it wasn't here. She just picked a random number. And then you put it into the guidelines and run child support.
Right, but on the first part of that, when you do alimony first,
Yeah.
what difference would child support have as to the father's income?
Difference would child support have as to
The
father's-
question that Judge Sachs asked was, the appellee's brief says, even if you exclude all the income that you're saying should have been excluded, the delta, the 30% difference, or the difference would still be considerably less than,
Or more. Yes.
if you did the calculations you're saying the judge should have done, the amount of alimony awarded is far less than 30%. And I heard your response to be that it didn't consider child support as part of the income calculation. I'm not understanding that.
Yeah, well, I think, for one, it's not always just a straight-up 30 to 35%. You have to look at the need of the recipient, especially in high-income
Sure, and it was
cases.
quite a bit less than that here, but is there some case saying that alimony and child support combined should ordinarily fall below or not in excess of 30 to 35%?
No, and so I think Kavanaugh was designed to protect women who have no children who would receive more support than a woman with a child. So you look at the analysis in fashion and equitable order that remedies that. So I think the reason the 30 to 35% always exceeded the child support guidelines. When you ran them, 30 to 35% was usually much higher than the guidelines would provide. So the Kavanaugh, I think, was designed to level the playing field, and you kind of look at step one and step two, and then fashion an order that makes the most sense for the family, taking into consideration tax consequences. But where I think you still get into the need of the recipient and lifestyle regardless. In very high income cases, oftentimes 30 to 35% doesn't make sense. So here, when you look at the need of the mother, her need only increased $9,000 per year.
Well, that's because she was taking out home equity lines of credit and running up her credit card debt in order to maintain a similar, though not the same, lifestyle as that the parties had during their marriage, right? The judge made those findings.
Yeah, but if you look at the trial financial statement from the divorce, her home equity line of credit balance was $98,000. And at the time of the modification trial, it was $108,000, an increase of only $13,000. And the way she operated was that at the time of the divorce, at the time of the modification, and throughout all of the intervening financial statements, she would go up and down on her home equity line to subsidize, and then when she would get a capital infusion from assets that were paying out from the divorce, she would pay that down. She also incurred $150,000 of legal fees in connection with this modification that she was using to pay for from her home equity line of credit, not tethered to her ongoing expenses. If you look at her ongoing actual expenses, they increased $9,000 from the time of the divorce per year. The time of the divorce to the time of the modification trial, $100 per week of which was related to the children, $5,200 a year. There was and the judge on the child support component she conflated two concepts, deviation from the guidelines and considering income above the combined earned income of $400,000 for when you deviate upwards.
Yeah, you cited a couple cases saying that when a judge awards support on a combined income over $400,000, the judge has to make specific findings about why. I think you cited MC versus TK and Cooper. I couldn't find that proposition in either of those cases or in the guidelines. I understand the guidelines say when there's a deviation, there need to be specific findings. And the judge cited both rationales. But does she have to make findings where there's combined income over 400 and
Yeah,
she
I think
increases?
some of the case law speaks to you have to look at the children's reasonable needs to order income on combined earned income of the parties over the 400,000, as opposed to the presumptive order that exists when you just calculate it using the combined earned income up to 400,000. And there was no analysis of the children's needs here. And the mother's financial statement indicated $100 per week increase in the kids' expenses since the divorce, which is $5,200 per year, which is far less than what the increase in the child support was overall. And I think she conflated the notions of deviation, which usually pertains to child support guidelines orders under the 400,000, and there's various factors you look at whether you can deviate up or down, with the concept of ordering child support above the income threshold, which has to be tethered to some needs of the children.
Yeah, is deviation a proper way of looking at the issue here?
It could be, given the parenting schedule issues here. And I acknowledge there should have been some increase in child support, just not the extreme increase that we saw here from $600 per week to $1,400 per week, where that's an $800 per week increase, where there's no nexus between or why or what or how, what portion was being allocated because of a deviation for some reason under the guidelines, or what portion of that 800 was connected to their income above the combined earned income of the parties of $400,000. So I think the judge erred in that regard. And there was also no mention of the fact that my client paid $72,000 for Caden's extraordinary expenses incurred in 2020 and 2021. I thought at minimum that would give him some relief on the retroactivity of the child support award retroactive.
Well,
to
it's in the
date.
findings. It
was
might not be
referenced
in the
that he paid
rationale,
it.
but it's in the findings, and she notes that how much each party paid, it seems to be roughly commensurate with the difference
Yeah.
in their income, so.
There was a reference that he paid it and that she paid it, but there was no consideration for it whatsoever, even though allocation of the children's extraordinary expenses was an issue on the pretrial order for trial. She didn't even allocate them in any respect. She just said who paid what. She didn't say,
But if it's roughly commensurate with their respective incomes, isn't it inferable that she did consider it?
I think, I don't know how that doesn't factor into the retroactive award when it was an issue for trial, and it is in the nature of child support. So I think it was a fact that she found with zero implication in her judgment, and it should have had some sort of implication because it was highly relevant. And the fact that the children's expenses going forward, as reflected on mom's financial statement, were only an additional $100 per week, and then the child support went up $800 per week, and then alimony went up as well, even though there was no connection between the increase in alimony and mother's need, or there was no calculation 35%. If your honors are correct, it would come out extra or more than she ordered. I don't think the judge would have ordered anything in excess of what she ordered. I think what she ordered was not tethered to really anything. She didn't show her work, so to speak. She didn't say how she got to her result. She picked appropriate numbers and then
Well, she considered all of the alimony factors, didn't she? I mean, she recites them and applies them at
yeah, she does attempt
page 27 of her decision.
Yeah, she does attempt to go through them. I think the lifestyle ones in particular were perplexing to me, insofar as especially from the father's lifestyle was informed part on $2,300 per week that he was incurring to contribute to capital calls for his work, which is a significant amount, and that she said...
She didn't just pick the numbers out of the air. At least she recited the relevant factors and said how they applied here.
Yes, and I think was against the weight of the evidence, though, to say that my client's lifestyle was lavish and mom was struggling. Mom bought a BMW after the divorce. She was not spending $9,000.
Well, it doesn't cost quite as much. It's cost about a third of the Porsche.
Yes, Your Honor, my client did finance the Porsche, and he did buy it. I acknowledge that. She still lived in the marital home. She was still going on vacation. She increased her retirement contributions from 5% to 10% of her salary. She still had a job. She renovated her home. It wasn't like she was struggling. Yeah, she continued to use the revolving line of credit, but that was no different than what she had been doing all along. And, there was a contempt hearing that cost her a significant amount of money in 2019 in legal fees, and then there was this modification that cost her $150,000. So I think when you look down her actual lifestyle, other than the fact the judge said she didn't belong to clubs anymore, and my client belonged to a golf club in Cohasset and then now belongs subsequently to a golf club in Colorado, which was part of his quote-unquote lavish lifestyle. I mean, his lifestyle subsidized by his fiance, but I don't think that should form the basis of an increase.
All right. Seeing no further questions, we thank you for your argument, and we'll hear from the mother.
Thank you.
Mr. Fitzgerald.
Morning, Justices. May it please the Court, Mark Fitzgerald here on behalf of Monique Armstrong, along with my colleague Victor Tice. If you take a look at the totality of the circumstances in this case, Judge Moses got this clearly right. When you look at the principles of the Massachusetts Child Support Guidelines and the statutory factors under the alimony statute under 208-53A, Judge Moses made careful findings and a careful judgment in a particular case.
So what about the requirement for specific findings when you deviate from the guidelines? she didn't make findings in support of the deviation specifically. Do we need to remand?
I don't believe you do. I think within the findings, there are, obviously extraordinary details regarding the parenting piece. From November of 2020.
But there's no, I mean, we don't know what she took into account in deciding that there was a deviation. We don't know if she would have reached the same result if she had ordered the increase based solely on the combined income being over $400,000.
I think it was a multitude of factors, Your Honor. It was the lavish lifestyle that she references within her judgment and findings over and over again. It was the significant increases in various forms of income, including the gift that Mr. Smith received from his father, and it was also the situation overall situation with my client, with Ms. Armstrong, completely taking on the burden of, and I hate to use the word burden, but completely taking on the responsibility of managing the entire household.
But where the guidelines require findings for a deviation, and we don't, and the judge referred to deviation repeatedly as one ground for her decision, why don't we need to remand for findings?
Again, I think there is plenty of information within the findings and judgment which provide Your Honor with enough detail as to why the court in the Norfolk Probate and Family Court made an upward deviation. It has to deal with, obviously, again, significant issues with regard to parenting and also the significant increases in father's income post-divorce. Those two factors in and of itself were enough to result in deviation. The court also cited cases such as Brooks v. Paella and also pointed to the guidelines in particular when there's a gross disparity in income. The guidelines specifically discuss that particular scenario within the context of any particular case, and Judge Moses was very careful to point out in her findings and in her judgment that there was a significant gross disparity of incomes. My client's income, Ms. Armstrong's income alone at $110,000 after taxes was about $70,000 net without child support and alimony. Mr. Smith had an extraordinary amount of income. His gift alone of $900,000 that he received from Caitlin, he testified to the court that he simply set aside that money. Meanwhile, my client, during the time period from the divorce until the time of the modification, was debt financing the lifestyle in order to provide for the family. There was clear and unequivocal evidence as well, Your Honor, of the children's needs. Children were involved in skiing,
I want to go to some
tennis.
of the specific points that the father raises, perhaps in order. What exactly was the mistake regarding tax consequences? And you seem to suggest in your brief that it's not material.
I don't think it is material. I heard your question about whether or not my sister counsel brought in a tax expert.
Well, it wasn't whether she brought in a tax expert, but whether information about the tax consequences of different alternatives was provided by father, and whether he argued for a specific different approach based on the taxes that were paid or would have to be paid.
Sure. I mean, we cited in our brief the issue of this particular issue. There is an error within the judgment that cites that this didn't apply to the Tax and Jobs Cuts Act because the parties were divorced in 2018. So the alimony that Ms. Armstrong was receiving was includable as income and deductible to Mr. Smith.
And is that only for the period in 2018, or is that the entire retroactive amount and going forward because the divorce itself was final before the act took effect?
No, the divorce was final before the act took effect after the divorce was final.
Okay. So does that mean that all alimony and all alimony under that is subject to the pre-act?
It does mean it, but obviously under Openshaw, the court has the ability to change that particular order to make it non-taxable, which is exactly what Judge Moses did. And she made it retroactive as non-taxable alimony to both parties. She does cite within there that there was an error in the way she cited that the Tax and Jobs Act didn't apply at that particular time. But even if that particular narrow issue is sent back, I think it's pretty clear Judge Moses did hear from a CPA at trial. She did hear that the CPA do a tax analysis, and in essence, she ignored that analysis and provided a decision where there was no tax consequences within the alimony and child support piece. And she came up with that particular figure. In fact, if you refer to the LJS and JES case, it's the burden of either party to bring forth a tax specialist. And the only party that brought forth a tax specialist was the plaintiff, or actually Monique Armstrong in that particular case. So, and both parties had the opportunity to do so at the time of trial. The Kavanaugh case had already come out. We filed a motion to allow for a tax analysis to take place. The trial was scheduled to be on consecutive days, and it was moved to October to provide parties with the opportunity to do that particular analysis. When the decision came out, Judge Moses made the determination that she was going to do this analysis post-Tax and Jobs Cut Acts. The percentages, as you saw in our brief, are significantly lower than what the percentages, so to speak, in 208-53A talk about 30 to 35%. But you can't get to 30 to 35% if you don't do the analysis on need and ability to pay. And that's where Judge Moses came up with the alimony figures. There was an ability to pay, clearly, and the needs were established. So there's nothing within Kavanaugh that I saw that requires a calculation, some sort of calculation that requires every probate judge in the Commonwealth to show their math. She based her math
on the alimony piece.
On the alimony piece. She based her math on a needs-based argument, which is purely proper and within the statute, and quite frankly, the way in which it's supposed to be. It's not always just going to be 30 to 35%. It's not. It can be, and now obviously with the Tax and Jobs Cuts Act, the percentages are typically in the 22 to 28%.
I want to ask you about the exclusion or inclusion of the Cadlin LLC income in the calculation. So that would appear to fall within the exclusion that was in the Exhibit A, I think, to the separation agreement. Now, perhaps there's a material change in circumstances that would have allowed a change in the amount, but the judge seemed to be setting aside, not just changing the amount, but changing what could be considered in setting the amount. In other words, disregarding that agreed-upon exclusion. Does that have to be sought in the mother's counterclaim for modification to set aside that provision?
I have three responses to that. Thank you. Number one, yes, it merged. Number two, there was a material and substantial change in circumstances. And number three, there is a distinction with a difference. That the Cadlin LLC was a gift from father.
Right. So we understand she found it didn't fit within the inheritance, but father is now saying, well, then it was investment income.
I don't see it. Well, again, I think it's a distinction with a difference. It was a gift, not necessarily investment income. It was a gift that may or may not have become further income that was provided to Mr. Smith. But this wasn't a situation where he took an investment like from Longworth and grew it into a different investment at an institution. This was a gift from his father that immediately provided him with $500,000.
Well, there was a new Longworth fund that plainly is investment income, right? And the judge considered that as well.
Yes.
So how can you reconcile that with the language of the separation agreement?
I would go back to answer number 1 and 2. It's a merged agreement, and it's a material and substantial change in circumstances to warrant new investment vehicles to be considered for alimony. But even if, and we put this in...
The paragraph in Exhibit A, the way it's worded, says if there's a modification complaint filed based on a material change in circumstances, the following sources of income shall be excluded. So it seems like it already considers that there is a material change in circumstances, and notwithstanding that, these sources of income will be excluded.
I understand which paragraph you're looking at, and certainly then I would go to certainly it's a merged agreement. Alimony, that paragraph did not survive, nor did any of the provisions within alimony survive. The alimony provisions are merging, so certainly at the end of the day, if there was changes in circumstances that Judge Moses felt were necessary to basically ignore provisions within that particular paragraph, she has the discretion to do so. And also, as we put in our brief, these were new particular funds that certainly could have also been calculated under the child support guidelines as well.
So the
based on
change in
additional
circumstances being that this fund didn't exist at the time of divorce?
income. Correct.
Shouldn't the judge have addressed the father's claim about the extraordinary expenses? It was listed as an issue for trial. There was a significant disparity in the percentages contributed.
Well, there's a significant disparity in their incomes and assets, too, Your Honor.
Right.
At the very least, you have Mr. Smith, who has at least $8.3 million in assets that he didn't even fairly disclose on his financial statement when he filed it with the court, and that we had to go through extensive cross-examination to make that determination. There's also a significant amount of income that Mr. Smith earned, especially in 2021. And I would submit to you that, to my client's credit, she contributed approximately $30,000 to the treatment of this child who was going through these very difficult times. And she took on the entire burden of the physicality and the emotional side of things to handle this situation, which is part of this whole thing. Fortunately for this child, both parties were able to financially take on this responsibility, but I don't think it comes into play in any factor whatsoever with retroactive support, because both parties contributed financially to the situation.
So we have to make assumptions about what the judge was thinking about that and say, well, she didn't address it specifically, but here's what she must have been thinking to not address it or to not make some specific adjustment because of it?
Well, I don't know if we don't read what she was thinking. She references in the findings
Right,
the expenses.
but in the rationale, we never see how that affects her decision.
But I would submit to you that seeing is believing, and what she did reference that each of them took on a financial burden. It was clear that Mr. Smith was able to pay for a greater amount of it based on his, greater income and assets that he had, and Miss Armstrong was able to pay as well, and I think it's referenced in that, and that's why it's not part of the overall decision with retroactive support. I mean, keep in mind that during this modification process, I know it came up and everyone chuckled a little bit, Mr. Smith went ahead and, again, moved out of Cohasset to Dover, sold his New Hampshire property, and then moved to Telluride, Colorado. Whereupon, when he went to Telluride, Colorado, he purchased $100,000.
So he joined an expensive golf club. The parties belonged to golf and tennis club and a sailing club in Cohasset. Mm-hmm. So, I mean, the fact of belonging to a private club is not so different.
Well, it was different for Miss Armstrong. She wasn't a member at any of those clubs post-divorce or during this process. And so what I'm saying to you, Your Honor, is that he was able to enjoy this type of lavish lifestyle while my client was, again, debt financing the overall family and taking care of the home while he was flying off to Colorado consistently.
Is that in the record that these club memberships in Cohasset lapsed?
It's on the record, yes.
Is that in the findings? I don't recall, but.
It was in the testimony.
Yeah. Okay. So what was the justification for disregarding the parties' agreement in the settlement agreement that the bonus income would lead to a lump sum of $18,000 in extra alimony annually?
Well, three answers as well, and maybe a fourth. I'll start with the fourth. Judge Moses specifically stated that with the Kavanaugh analysis being completed and with the child support and alimony figures both retroactively and the current alimony that there's no longer a requirement for the bonus income to come into play. And in fact, actually...
Well, but she disregards it at the outset of the Kavanaugh analysis without explanation that I could see. I mean, the clear implication, I think, at least of the settlement agreement is that, or separation agreement, excuse me, is that that bonus income is not going to be considered as income for alimony purposes because a lump sum of $18,000 is going to be paid on it as alimony. And now the judge says, well, I'm going to do these calculations and I'm going to take that into account.
Well, again,
without, yes, the judge is not bound by the agreement, but we have cases saying that the judges should respect agreements to the extent possible.
Well, we also have cases, though, that the parties are not, that if it pertains to the children, that even if the parties agree to something that
sure,
is not necessarily
but this is
bound
about
by that.
But this is about alimony.
Sure. Let me again, I think this pertains to a merged agreement, a Kavanaugh case that came out, and in fact, if you annualize that $18,000 bonus over the year as a weekly amount, the amount of alimony that Mr. Smith is paying now, based on my calculations, is about a $346 a week increase. So it doesn't specifically say that within the judgment or within the findings, but again, based on the totality of the circumstances, as I started out in my argument, I believe that Judge Moses took all of this into account when she factored that in, and at the end of the day, she looked at their marital lifestyle and made a decision that there was a material change in circumstances, this agreement merged, and mom's lifestyle was nowhere near what dad's was, and it wasn't the lifestyle that they led during the marriage.
Okay. All right, thank you very much. Thank you both for your arguments. I want to thank our court officers and court staff for their assistance today, and with that, we are adjourned.
For our rise, please.